Many people believe that a divorce case ends when the judge signs the final decree, but enforcement issues often arise later when one spouse refuses to honor obligations like spousal support, child support, or property division. In Illinois, trial courts retain jurisdiction over domestic relations orders, and they have inherent power to enforce them. If a spouse disobeys a support order, parenting time order, or property division, the other spouse can return to the divorce court for help. This ongoing authority allows the court to protect the terms of the judgment and ensure fairness even years after the divorce. When a party needs compliance without punishment, they can file a motion to enforce. A motion to enforce is a straightforward request asking the court to compel compliance. It cites the violated order and explains what has been disregarded. The person filing gives reasonable notice, which can be mailed, and there is no requirement for personal service. Because it is a motion, the court can hear it quickly and simply direct the non-compliant party to follow the original decree. This tool also helps the judge understand the story of what has happened without the technical elements of contempt. Sometimes a motion to enforce reveals that the original order needs adjustment. Modifying a divorce order requires a showing of a substantial change in circumstances, but a motion to enforce can be paired with a motion to modify maintenance, child support, or parenting time if needed. This path is ideal when the focus is on cooperation and speedy compliance. If the violation is egregious or persistent, a petition for rule to show cause may be appropriate. A petition for rule to show cause invokes the court's contempt powers and initiates an indirect civil contempt proceeding. Illinois local rules require the petition to identify the order allegedly violated, attach a copy of the order, and be properly verified and personally served. The petitioner must make a prima facie showing of disobedience. Once that burden is met, the alleged contemnor must demonstrate why they could not comply. The court can order the contemnor jailed until compliance, but this imprisonment is coercive, not punitive. The order will include a purge clause describing how to avoid or end incarceration. The court may also issue a body attachment to have the sheriff arrest the contemnor and bring them to court. When the court finds contempt, it may award them avant reimbursement of attorney's fees, reflecting the time and effort spent pursuing compliance. This process is more complicated and time-consuming, but it signals that the judge is serious about enforcing the order. Choosing between a motion to enforce and a petition for rule requires careful analysis by a divorce lawyer. A motion to enforce is often sufficient when the goal is to remind the other spouse of their obligations and secure prompt compliance. This approach is less adversarial and can preserve a working relationship between the parties. A petition for rule is better suited to flagrant or repeated violations, where the threat of contempt is necessary to motivate obedience. Some attorneys file contempt petitions too quickly, hoping the specter of jail will compel action, but this tactic can backfire. A responsible attorney will discuss both options with the client, explain the legal requirements, and choose the path that maximizes the chance of compliance while minimizing unnecessary conflict. The law office of Russell D. Knight is a law firm that has handled many enforcement proceedings and can help spouses understand their options. An experienced divorce lawyer will consider the facts of your case, whether a motion or a contempt petition is appropriate, and how best to protect your rights. If you need assistance enforcing or modifying an Illinois divorce decree, contact the law office of Russell D. Knight at 1165 North Clark Street, number 700, Chicago, Illinois, 60610, or call 773 334-6311 to speak with an attorney about your situation.